Alyssa Young. Alyssa Leanne Young. 25B718619. Is she yours?
Yes, Judge. That's a Brownstown case. I believe that she's on Zoom. Detective Tula said that she's in.
She's coming in now.
All right. So I got Alyssa Young, Lexi Don, that's on Brownstone's docket. All right. Good morning. Your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
And where is the defendant?
I have them both sitting here with me. I have Miss Dawn and
Let's
I
bring
have Miss Young.
Miss Young in there, please.
All right, Miss Young.
Your name, ma'am?
Alyssa Young.
All right. State your name again, counsel.
Good morning, Your Honor. Mr. Sheriff, prepare you have my client stand set for mitigating her Zoom as the arraignment wait for where my client seems to be.
All right. So she's got here. It looks like 3 counts of OWI occupant less than 16, which is a 1 year. Does she have any prior alcohol related convictions? Can anybody tell me?
No, Your Honor.
Can you tell me what the breathalyzer or blood result was?
Yes, Your Honor. The intoxilizer results were a 141 and a 138. And at the time, she had her children, 3 children in the car. That one that was born on June 19th of 2019, one that was born on October 29th of 2021, and the third one that was born on February 13th of 2023.
Where do you live now, ma'am?
Inkster,
What is your address?
26716 Ross.
ROSS?
Yes, sir.
What's the zip code in Inkster?
48141.
Who do you live there with?
Myself and my 3 children.
Do you work?
I do. That's where I was coming from.
Where?
I work at Burger King on Michigan Ave. About 5 minutes from my house.
What are you asking for there? Anything, detective?
Your Honor, we would just ask for an order that she not be able to purchase, consume, or possess alcohol. We'd also ask that she have a sober linked tether, given the severity of the offenses and the 3 children in the car. Otherwise, we would leave it within the discretion of the court.
Any argument, counsel?
Your Honor, she's gainfully employed. Obviously, in the circumstance, she probably and she doesn't want to be a standard employment. I asked the ratio for her personal bias irregularity.
You got warrants out for your arrest. If I set a bond that you can't make, who's going to take care of your children, ma'am?
I don't know, because I'm their primary caregiver and my daughter's disabled from her neck down, but I would have to make calls, and
Who's with the children now?
I believe their father.
Got to get your
Or my
life in
sister.
order. You got to get your life in order. Give her
Yeah.
an AA sheet. Ma'am, I'm going to give you a $2,500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to attend AA twice a week. Every time you go, and you do have to go in person, you have to have the form signed. Every time you come to court, you have to bring the form with you. Do you understand that?
Yes, sir.
All
May I
right.
ask, is it 10%?
No, I'm just going to give you a personal bond. You don't have to post
Okay.
any money.
Okay, thank
This
you.
is your lucky day, but you got to show up in court. Do not make this worse than it is. Do we understand?
I got
one
you.
another?
Thank you,
You
Your
have-
Honor.
You have to have that form signed, okay? Every time you go, the
Yes,
to
sir.
AA, and you have to go in person. October 28th at 8:30 will be your court date.
Yes, sir. Thank you.
Any questions?
No, sir. Thank you, Your Honor.
Don't make this worse than it is by not showing up, okay? Thank you.
Yes, sir. Thank you.
You're welcome. People against Lexi, Jane, Elaine, Dawn. 25B724898. All right. Detective, your name?
Good morning again, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. You solemnly swear affirm by the penalties of perjury, the testimony you're giving these proceedings be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, on October 12th of 2025 at approximately 9:03 p.m., Officer Lyles was dispatched to the area of northbound Telegraph Road near Sibley Road on the report of a reckless driver driving without their headlights on. As Officer Lyles was traveling south on Telegraph, he observed a black Ram 1500 truck traveling northbound on Telegraph Road at Brito Avenue in the right travel lane with its right turn signal on and no headlights. Officer Lyles turned around and attempted to secure a traffic stop on the Ram 1500 by activating his emergency lights and sirens. Despite the activation of those lights and sirens, the Ram 1500 continued northbound on Telegraph Road for approximately half of a mile and did eventually come to a stop south of the McDonald's restaurant located at 19051 Telegraph Road. Officer Lyles made contact with the driver, later identified as Lexi Jane Don, who is seated in the driver's seat and in full control of the vehicle. Officer Lyles also observed a small child in the rear passenger seat of the vehicle and a child restraint seat. Officer Lyles asked Miss Dawn for her license, and she informed him that she did not have it with her. He observed an unopened airplane shooter. Ladies, please be quiet. He observed an unopened airplane shooter of 99 bananas in the cup holder next to Miss Dawn. Officer Lyles asked defendant or Miss Dawn to step out of the vehicle. At that time, she rolled her window up and began talking on her cell phone. Officer Lyles ordered her to step out of the vehicle, and she complied, but stated to Officer Lyles, "You're not my dad." Officer Lyles asked Miss Dawn how much she had to drink, and she stated that she had one wine. Based on his observations of her driving and her admission to consuming alcohol, he administered several standardized field sobriety tests upon Miss Dawn. Prior to the administration of the test, he asked several medical questions to ensure that she could perform the test properly, and she indicated that she did not have any issues and she did not take any medications. The first test that he requested her to complete was a horizontal gaze nystagmus. After providing her with the instructions and confirming that she understood them, Officer Lyles attempted to administer the test. However, Miss Dawn failed to comply with his instructions and would not keep her head still, so she was unable to complete the test. The second test Officer Lyles requested that she complete was the one-leg stand. He fully explained and demonstrated the test, and she stated that she understood the instructions. While performing the test, Officer Lyles observed that she put her foot down multiple times after approximately 6 seconds and was unable to hold her foot up for longer than 2 seconds after she initially placed her foot on the ground. The final test that Officer Lyles requested that Miss Dawn complete was the walk and turn test. Officer Lyles fully explained and demonstrated that test as well, and Miss Dawn indicated that she understood the instructions. While performing the test, she failed to stay in the instructional position, failed to touch heel to toe throughout the test, and did not count aloud as instructed. After the administration of these SFSTs, Officer Lyles cited her preliminary breath test notice, and she consented to complete a preliminary breath test, which resulted in a BRAC of 0.196. Based on his observation, she was placed under arrest for operating while intoxicated. Subsequently, Officer Lyles spoke to Miss Dawn, who identified the rear passenger in her vehicle as her 1-year-old son, Josiah Amaya Davis, who was subsequently turned over to Forrest Clay Hughes, a friend of hers, at her request. Following her arrest, she was transported to the Brownstown Police Department, where she was read her chemical testing rights verbatim from the DI 177 form and consented to a chemical breath test. After obtaining the consent, Officer Lyles completed the required observation period and administered the test upon Miss Dawn, who provided 2 breath samples, which showed that she had a BRAC of 0.224 and a second BRAC of 0.223. After the completion of the test, she was booked, which included fingerprints and a mugshot and the subsequent collection of DNA, and she was lodged in cell 7 of the Brownstown Police Department. During booking, it was disclosed to Officer Lyles that Miss Dawn was 5 months pregnant. A subsequent criminal history check for Miss Dawn was conducted via lien, which showed that she had 1 prior alcohol-related conviction from April 30th of 2019 for operating while impaired, which she pled guilty to out of the 34th District Court in Romulus.
Based on your sworn testimony, I find the crime OWI occupant less than 16 second offense notice was committed. That makes it a felony since she had the prior impaired charge. Then I'm also finding that there's sufficient evidence to establish that the crimes of operating while intoxicated or impaired. Second, we're committed. So we have 3 counts, 2 counts of that. That's super drunk count 2. Count 3 is regular OWI 2. All right, so I'll authorize the issuance of the complaint warrant. I'll note that you signed the complaint. Court is signing and dating the complaint and the warrant for the arrest of the defendant. You can bring her before the camera if you would, please.
Yes, Your Honor.
Ma'am, your name?
Lexi Dan.
Mr. Shemke?
Good morning, Your Honor. Chris Pacheco, Fairview, my client, 77th Mayor, Fairview. So as the arraignment waiver, we're reading my client's statement.
Ma'am, I'm going to advise you of your rights. You have a 5-year felony and 2 one-year misdemeanors. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
I do, Your Honor.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. Your probable cause conference will be October 28th at 8:45. Preliminary exam will be November the 4th. November the 4th at 10:45. So those are your dates. You're going to have to fill out a petition for a court-appointed lawyer going forward. Counsel, what would you like to say regarding bonds?
Your Honor, my client currently has 5 children, ages 14, 12, 10, 8, and 2. One of her children, she receives SS9 for a disability. She's currently a stay-at-home mother. She indicates she will appear in all future court dates. We respectfully request the lenient to support to consider when determining an appropriate bond. Thank you, Your Honor.
Does she work?
No, Your
How is she supporting herself?
Honor. She indicates disability for one of her children. I believe that she has family support.
Detective, what do you have to say?
Your Honor, based on the extremely high BAC on the case and the age of the young child, we would be asking for a sober linked tether, NA meetings, and would leave any other conditions to the discretion of the court.
I'm concerned because you just told me that she's 5 months pregnant. That concerns me if there's anything that concerns me here.
Just know that you're.
$2,500 personal bond. You cannot leave the state without the consent of the court. Yeah, well, don't shake your head because you're going to end up in the county because I cannot take a chance on you not getting your own scram tether or sober link. You cannot.
I don't understand.
law. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're not to have any contact with prosecution witnesses except through your lawyer. You have to fill out a petition for a court-appointed lawyer, and she's going to give you an AA sheet. You have to go to AA or NA, any 12-step recovery program at least 3 times a week, and you have to have the form signed. You have to go in person. Every time you go, you have the form signed. I understand you have a lot of kids. I don't know what's going on with who's primarily going to deal with them or take care of them when you're gone, but I cannot, you're not to be released is what I'm trying to tell you until you're fitted with a SoberLink device or a scram tether. So even though you're being given a personal bond, you're going to be taken downtown. They're going to fit you with a scram tether or a SoberLink device, and you cannot be released until then. I hope it happens sooner rather than later, but I will not hold my breath. October 28th at 8:45 will be your PCC. November 4th at 10:45 will be your preliminary exam. Do you understand everything?
I do.
All right. Any questions?
No, sir.
Maybe she needs to talk to her lawyers about sobriety court.
Yeah, I was going to ask about that, Your Honor.
Well, you talk to your lawyer about it. Good luck. Thank you.
Thank you.
Thanks, Judge.
Thank you, Your Honor. Have a good day. Okay, so what?
You too. Yeah, we're gonna do that exam, John.
You want him in right now?
Yes. Elizabeth Ann Gillum, 25M12532.
Good, morning, Your Honor. We're gonna be having Ms. Gillum, who's just going to the podium, and will be standing to my left.
Ma'am, your name?
Elizabeth Gillum.
All right, so this could be a plea to PBT refusal, right?
That's correct.
Was there something else on this?
So, Your Honor, I spoke with, Mr. Muhammad, and there has been a submission for drunk driving, but it hasn't been charged yet or anything. So, I mean, this isn't really going to impact the ultimate case because there was,
I see that, please.
so.
I understand. So, ma'am, you're going to plead responsible, can I see her? To PBT refusal, is that correct? All right, to that charge, how do you plead? Responsible or not responsible?
Responsible.
All right, I'll accept the plea 205. You can pay that today?
Yes.
All right, wish you well. Thank you.
Thank you.
Mindy Elaine Malmston, 25B722119, Malmston.
Your Honor, good morning, Nicholas Darren, on behalf of, the defendant. Your Honor, I have to apologize to the court. This case is a domestic violence, got about 5 motions up in the divorce case. And my office, when she asked, told her that the date is the 29th, but that's actually for the divorce. So she's not here. She could be here on Zoom. But all I'm asking for is an adjournment because I got the discovery from the domestic violence prosecutor. There was a mistake made by the officer. They uploaded the wrong video. And
So
so
I'm going to adjourn it 2 weeks, but was given a notice, right?
but Your Honor, after that.
October 28th will make it. Can you make it at 8:30?
Okay. Yeah, absolutely. 8:30.
At 8:30, and I'll be here. Okay?
We'll be in and out. I'll be ready to.
Good enough.
Thank you.
Thanks. Does anybody have any waivers? If you do you have a waiver or is yours going?
No, it's gonna be.
Is it ready?
Yeah. Yes, I'm signing.
Where's he in custody?
Yeah. You can only get one at a time. I know.
He's at MDOC.
Yeah, wait. He's Jackson. He's here. He's here.
Oh, okay. We'll get him out. Michael Dewan, Timothy Nelson, 25I-713-782.
Good morning, Your Honor. Michael K. Mr. Nelson.
Mr. Nelson's on Zoom, Judge.
Yeah. Okay, Mr. Nelson, start your video and state your name, sir.
Michael Nelson.
Good morning.
I'm not being allergic to.
Hang on. They
Can you
gotta
repeat?
stop talking back there, okay,
Yes,
please?
yes. Yes, sir.
All right, so your lawyer, there was no appointment of a lawyer, and then we called MIDC. They said to spot appoint. We did. Mr. Pieknik is going to be your lawyer. He needs an adjournment. He's requesting that the case be adjourned. You have the right to a probable cause conference within 14 days of the date of the arraignment. If I grant his request to adjourn, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you wish to waive that right?
Yeah, you're gonna adjourn it.
Anybody force you to do that?
No, sir.
I'll accept the waiver of that. You understand also that the preliminary exam will have to be pushed back a week, correct?
Okay, yes, sir.
October 21st will be the PCC. That will be at 9:00. And then the preliminary exam, which will be in person, will be at 10:45, at 11:00, at 11:00. Okay?
Okay, that's on the
You're-
23rd, right? Not
Today's the 17th or 14th. You're coming 1 week from today, the 21st, and you're coming 2 weeks from today, the 28th.
Okay.
Unless it resolves next week, in which case you don't have to be here. Okay?
Right. Okay.
Anything else?
May I just ask Mr. Nelson to confirm his phone number so I have.
Can you confirm his phone number with us so your lawyer's here and he can hear it? Okay?
Yes, sir. 269-264-2579.
Thank you, Judge. I appreciate the courtesy.
Thank you. Good luck to you, Mr. Nelson. See you here
You-
next week.
You
Christopher
too.
Scott Melkowski, 25T713927. Names?
Good morning, Your Honor. Mohammed on behalf of the people. Good morning, Your Honor. Michael Kennedy here on behalf of Mr. Malkowski. That's my left.
Sir, your name, please.
Chris Scott Melkowski.
This is a charge of possession of less than 25 grams of fentanyl. And there's also a fourth offense notice. It's my understanding the defense wishes to proceed with the preliminary exam, correct?
That's correct.
Any preliminary matters, Mr. Mohammed?
Yes, Judge, as a preliminary matter, I'm going to request a mutual order of sequestration with an exception for Detective Mark Driscoll.
Any objection?
Police officer, Detective Driscoll is the officer charged.
Also, with the exception of Officer Detective Driscoll and the defendant, all other witnesses must leave the courtroom. It doesn't appear as though there's any. There's one lawyer, one defense lawyer, and there's another young man who's going to be a lawyer in about 2 weeks when the bar results come out.
And Judge, just so the court is aware, Detective Dawn
Shapaniak?
Shapaniak is the initial officer in charge. Detective Driscoll is just standing there.
Okay, good enough. Anything else, Mr. Fiecki?
No, I believe he has stipulations.
Correct. And Your Honor, pursuant to the stipulation with the defense counsel, I'm seeking to introduce into evidence People's Exhibits 1 through 4. Exhibit number 1 is a copy of the mobile detect test in this case, which is page 8 of the discovery packet, and it indicates that the drug recovered tested positive for fentanyl. People's Exhibit number 2 is a copy of the clear bag that was recovered in this case, and that's from page 9 of the discovery packet. People's Exhibit number 3 is the copy of the scale with the drugs on top of it, which is People's Exhibit number 3, and that's page 12. And People's Exhibit number 4, which is page 13 in the discovery packet, is a copy of a photo of the scene of the crime.
Okay, good enough.
And just for
And you stipulate to the admission of those for exam purposes.
For exam purposes, but I want to clarify that in terms of the results, the one photograph that has the results, we're agreeing that that is a photograph results, but we're not agreeing that those results are actually accurate.
I understand, but for exam purposes, no objection to the admission. People's 1, 2, 3, and 4 are admitted.
Thank you.
Any other preliminary matters?
No, not with the people.
Counsel?
Not as a defense.
Okay, call your first witness.
But for the people's first witness, we call Miss Ariel Ashworth.
Come on right up here to this witness chair, please, man. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. All right, have a seat, please. Can you spell your first and last name for us?
ARIELASHLIN.
Thank you. You can proceed, Mr. Muhammad.
Thank you. Good morning, ma'am. I'm going to take you back to the date of June 5th, 2025. Were you at or near the location of 1700 West Road?
Yes, sir, exactly.
Is that located in the city of Trenton, county of Wayne?
Yes, sir.
And what were you doing at that location on that date?
I am the shift lead for the store, and I was working at that.
And on that date, when you were working at that location, did you observe something that drew your attention?
Yes, sir. I was at the photo lab with a clear direct line.
Can you keep your voice up just a little bit?
Sorry, yes. I was at the photo lab with a clear direct line of sight towards our front registers, and I saw a hand raised up from behind the counter, and I saw an individual taking cigarettes down, which we keep behind the counter.
Okay, and what kind of store was this?
Walgreens.
And the individual that you had observed grabbing the cigarettes, do you see that individual in the courtroom today?
Yes, fine.
Can you please point out an article of clothing that person is wearing?
He's wearing brown sandals.
And can you please point to that individual? Your Honor, please let the record Your Honor, please let the record reflect that the witness has pointed to and identified the defendant by an article.
Record should so reflect.
Thank you. And based on your observation, what did you do, if anything?
First, I made sure the individual was still in the store, contacted my store manager and how to handle the situation. When I reviewed the cameras and confirmed that I had seen what I'd seen, I contacted the police
And why did you contact the police?
because there were cigarettes being stolen.
And at any point, did you ever observe the defendant attempt to make a payment for those cigarettes?
No, sir.
No further time.
Cross.
Morning, Zach. How are you this morning?
I'm all right.
If at any time you can't hear me, just let me know, okay?
Yes, sir.
Great. Now, you said that you had seen my client reaching up and grabbing some cigarettes, correct? And you said you direct line of sight.
Yes.
Okay. Did you see any other of your coworkers there helping you?
Yes.
Okay. So there's no one around to help him get cigarettes.
Yes.
So he took some on his own then. You do that thing.
Yes.
Okay. And then you, at any point, did he ever leave the store?
Yes, sir.
Okay. Is the cash register, is it toward the front of the store?
Yes.
Okay. And he never walked past the cash register out the door.
Yes, sir.
So when you had indicated that you thought he was stealing cigarettes, you really never had a chance. You really don't know that because he didn't not hang lock out. You agree that?
Yes.
You agree.
Can you rephrase your question, please? I'm sorry.
Okay. He never walked out of the store and stole the cigarettes, there.
He did not walk out of the store, but they were put into his jacket at the time.
Okay. I mean, I saw a photograph of lots of cigarettes, right? Okay.
Is that a yes?
Yes. I'm sorry.
Did he have a shopping cart or a basket with him or anything like that?
No, he had a bag that he brought in.
So something to carry.
Yes.
So what you confirmably tell this court is that no one was there to help him. He helped himself to some cigarettes, which probably the store doesn't want, but he did it. And he was still in the store when the police came. Is that all correct?
Yes.
Right. And at no point did he try to run out of the store and steal the cigarettes.
No.
Okay. And he didn't have a shopping cart, so he put them in his pocket to carry around. Is that fair?
Yes.
Great, Ms. Ashton. Those are the questions I had for you. Thank you.
Ma'am, at the time you had observed the defendant obtain this pack of cigarettes, did you see exactly where he went to obtain the cigarettes from?
He stayed behind the register, and we found him in the large aisle in the middle of the store as he was still walking.
And do shoppers have permission to go behind the register?
No. Sir.
Is that for employees only?
Yes.
No further questions.
Anything else?
Oh, yeah. You said something earlier that I didn't catch. Maybe that's on my turn. You said that there was a register there.
Yes.
Okay, and then does it make sense that the door is right there as well?
Yes.
Okay, so he was at this grab the cigarettes by the register, and instead of walking out the door stealing, went back in to continue shopping.
Yes.
Oh, perfect. I'm just
You can step down. Thank you.
If I can, quick follow-up. And ma'am, where specifically did you observe the defendant put the cigarettes?
In his jacket. On his person.
He didn't put it in the cart, correct? Let me see.
You can step down. Thank you. Call your next witness.
People call Officer McLeod.
Thank you for coming, ma'am.
thank you, man. I appreciate that.
Right up to the witness chair here, please. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth to help you God.
Okay.
Have a seat, please. Can you just spell your last name for us, please?
MACLEOD.
Thank you. You may proceed.
Thank you. Good afternoon. Officer McLeod, can you please restate your name for the record?
Officer Evan McLeod.
Officer, are you currently employed?
Yes.
Who's your employer?
Trenton Police Department.
And in what capacity are you employed there?
The police officer.
Were you employed in that capacity as a police officer on June 5th, 2025?
Yes.
You worked that day?
Yes,
You worked that date by yourself or with a partner?
I rode by myself.
On that date, did you work in full uniform or modified uniform?
Full uniform.
Did you operate a scout vehicle or did you work foot patrol?
Scout vehicle.
Did your duties as a police officer on the date of June 5th, 2025 take you at or near the location of 1700 West Road?
Yes.
Is that located in the city of Trenton, County of Blaine?
Yes.
What's at that location?
Walgreens.
And what took you to that location?
A dispatch call.
And what was the nature of the dispatch call?
Dispatch call was reference to a male stealing items from behind the counter.
And did you learn pursuant to your investigation what specifically those items were?
Cigarettes.
And when you made that location, what did you do, if anything?
I'm sorry, can you repeat that?
When you made that location of 1700 West Road, what did you do, if anything?
When I got there, I made contact with the caller who was the employee.
And what did you learn?
I learned that a male was stealing, or she advised that a person was stealing items from behind the counter
Were
and
you-
pointed the male out.
Were you able to locate that individual?
Yes.
Do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that person is wearing?
Yes, he's sitting right there, green bottoms and green top.
Your Honor, please let the record reflect that the witness is pointed to and identified the defendant.
Record should so reflect.
Thank you. And did you make contact with the defendant when you were at the location?
Yes.
How did that begin?
I located him in the aisles, and based on information from the clerk, I detained him in handcuffs.
And what specifically did you do next?
I handcuffed him, and then I searched the person and located the cigarettes.
And where did you locate the cigarettes?
They were stuffed into his shirt.
And based on your training and experience, is an individual tucking a pack of cigarette inside their shirt and
Based on my training and experience, that would be that they were attempting to steal them.
and did you discover anything else pursuant to your investigation?
Yes, I also located a clear plastic baggie with multiple white pills and a white powder substance that I suspect to be cocaine.
Your Honor, may I approach?
You may.
The exhibits? Yeah. Also, officer, I'm handing you what's been marked as People's Proposed Exhibit number 3. I'd like you to take an opportunity and review. Do you recognize that?
Yes,
I don't recognize it.
it's the baggie that I found on Mr. Tomkowski.
Is that a fair and accurate depiction of the baggie you found on that individual?
Yes.
Does that appear to be altered or manipulated in any way?
No.
Thank you. And, sir, upon making that recovery, what did you do next?
I placed him under arrest
What for?
for violation of the Controlled Substance Act.
And why did you conduct an arrest based on that? Led you to conduct the arrest based off of the substance? What about the substance led you to believe it was anything?
It's based on my training and experience.
And can you describe what that item was specifically?
I'm sorry, can you repeat that?
Can you describe the clear bag? What about the clear bag led you to conduct an arrest?
It's where drugs are commonly held.
Can you describe the items inside of the bag?
They're approximately 3.5 pills and a white powder substance.
And what about that led you to believe that it was drugs?
Based on my training and experience,
What kind of drugs did you suspect that it was?
I suspected it to be cocaine.
And did you do anything to further your investigation and determine whether or not it was cocaine or any kind of a drug?
Once we were back at the station, I field tested it with the mobile detect field kit, and in return it was positive for fentanyl.
Your Honor, may I push the witness?
You can.
Sir, I've handed you what's been marked as People's Exhibit number 1. I'd like you to take an opportunity and review that. Do you recognize that?
Yes,
How do you recognize it?
it's the results from the field test that I performed.
And what did you learn upon conducting a field test on the drugs that you recovered, or the suspected drugs at the time that you had recovered?
The white powdery substance that I tested resulted in it tested positive for fentanyl.
And is that test result a fair and accurate depiction of the results that you concluded upon testing the drugs in question?
Yes.
Does that appear to be altered or manipulated in any way?
No.
No further questions, please.
Ross?
Borrow that one photograph. There's one exhibit, but you have all the photographs? Okay. Thank you. Madam First Witness?
Yes.
On that picture for me.
What did you show him? What document? What exhibit?
I'm sorry. I handed him what's been marked as exhibit 4. The photograph of the cigarettes. Officer, you took that one?
I don't believe I did. I'm not sure.
Okay. It makes sense now, right?
Yes.
And those are the cigarettes that my client had on.
Yes, sir.
How many packs of cigarettes?
I think it was approximately 19.
Did he have a carbon?
Yeah.
Well, buddy, did he have a little hand basket in that?
I don't recall.
It's against the law to shop but not use a basket. It's against the law to shop and not use but.
Yeah.
Okay. And if he wishes to buy 19 packs of cigarettes, or to carry, fair. So, when you arrive at Walgreens, where is Border Control there?
Next to the building.
Right, and then you walk in directly.
Yeah.
Okay. At any point, there's a mic line outside of it.
No.
When you briefly served my client, what was he doing?
We walked down the aisles.
He came to shop.
I didn't know what he was doing.
Yeah.
I asked him to stop and walk away.
So you issued an order to detain him by asking him to stop.
Yeah.
What's the basis for issuing that order?
Based on the information I received from the caller who was employed.
And so the caller had said that there was the person who had taken cigarettes from behind the counter.
Yes, sir.
Is it illegal to take cigarettes from behind the counter?
Generally speaking, you would get them from the employee.
That's not the question I asked you. I asked you, is it illegal to take cigarettes from behind the counter?
Or behind the counter. I'm not sure in that sense if there's signs.
I'm not asking about Walgreens policy. Now, you'll probably have a suspicion of what the policy is. I'm asking you, under Michigan law, federal law, or any law that you've been trained under, is it a violation of the law to take a cigarette from behind the counter? Okay. So you stopped him on what basis? If it's not against the law to take the cigarettes down and he's continuing to shop, what was the basis for your stop?
Basis was that he was concealing them and going to walk out of the store with them.
Now, you just said he was going to walk out of the store. Where in the store did you encounter?
It was in the middle of the store.
And door was up front. So how do you know he was going to go out? You just kind of guessing.
Based off my training experience,
You have training inside of Walmart, what the shopping patterns are inside of Walmart?
Yes.
Okay, you know. And in fact, professional marketers have training on how people do in Walmart. So they know what to put stuff. But you, on the other hand, do not. Okay, fair. Okay. So you issued an order to stop him based on something that wasn't even illegal. No. So you're not saying it isn't illegal to take cigarettes from behind the counter? I thought we covered this.
I think he's answered this, right? He said his knowledge was that they were concealed. You can't. He's answered this question a couple times.
It changed the answer. Gotcha. So I'm telling you, get into that.
Okay, go ahead.
So my client is carrying cigarettes around inside the store. Granted, not in a buggy or in a basket, but he's placed them inside his pockets and his shirt. He's walking around shopping. Are we tracking so far? Again, you stop him and arrest him.
They detained him.
What's the difference between detaining and arresting?
They detained him that there was reasonable suspicion that he was committing a crime.
And that suspicion was because he taking cigarettes from behind.
I think he already answered this. He concealed them, right?
Well, that's his charge, Judge. I'm using carry. I'm a little.
Well, he said they were stuffed in his shirt. The clerk said that they were stuffed in his jacket, or he concealed them in his jacket. I don't know where you're going. I mean, I don't want to stop you, but
Well, he also said 19 cigarettes, Judge. How are you going to carry around 19 cigarettes? You got to carry them somehow. And when you put them in your jacket, put them in your pockets, he's carrying them around. And so,
it's like bubble gum, right? I mean, remember the old bazooka bubble gum? I mean, if I stuffed 19 of those in my pockets, I certainly have the intent to steal, don't I? Okay. All right.
here's the thing, Judge. I think we're transitioning yard. He's been stealing. We had to want him to stay right by the door. He walked out the door.
Okay, go ahead. Continue your questions. You can argue when you're done.
Yeah, I apologize. Judge.
You're fine.
Jumping to conclusions, but I think we both know where we're going with this. I'm a little disappointed. Not feeling it, but we'll see. So, when did you arrest him?
I arrested him. I placed him under arrest after I located the suspected cocaine.
To locate the cocaine or the suspected cocaine, you had to search him.
Yes.
Okay, where did you search?
I searched one of his pockets. I don't recall which pocket it was that I located.
Where you?
In the middle of the
No, so I had a long story.
correct?
You searched. Did you handcuff him first?
Yes.
So at the point you handcuff him, you arrested.
I was detaining him at that point.
And when you handcuffed him, he's no longer free to go.
Correct.
You read his rights?
No.
Okay. And you searched him, and what was the reason you handcuffed him?
The reason I handcuffed him was on the reasonable suspicion that he was stealing cigarettes.
Officer, thank you for your time. And those are the questions I have for you. I think Your Honor has a good idea of this.
Redirect, if any.
Thank
You can step down. Call your next witness.
no further witnesses.
People move the bind over.
Correct.
Any argument?
Yes, Judge. It's fruit of the poisonous tree. You may have clearly heard from the employee there that no one was there to help my client, so he helped himself. Not a crime. The Walgreens doesn't agree with it. It doesn't rise to the level of a crime. Then in a shock, he goes around. Now, granted, he didn't grab a luggie, he didn't grab a basket, and he wants 19 packs of cigarettes, right? So he's carrying around 19 packs of cigarettes, and he puts them in his pocket. They use the stuff down the shirt. They use some very, some creative adjectives here. But what we didn't hear from people is my client had the ability to take for it. They searched you. They didn't enter with any evidence for you to decide whether.
What's the ability to pay for it have to do with it?
Well, if he's got
So if I have $100 in my pocket and I go in and steal $82 worth of items and conceal them and walk around the store, you mean to tell me I had the ability to pay for it, so they shouldn't charge me?
No, Judge, it means if you have $100 in your pocket and you grab some things and you're walking, in your words, you're walking around the store, which means you want to continue to shop.
Concealed.
You're going to
You keep forgetting the word concealed. Stuffed into his shirt, stuffed into his jacket. You can't conceal items.
That's carrying, Judge.
Uh,
I mean, how are you going to carry it? We got all those things. It's not a crime not to have a basket. And he had the opportunity, or their own witness. He's right by the door. If he was going to steal it and walk out, instead he's continuing to shop. He's got the stuff he wants to buy, carrying it with him, and they stopped. And I think it stopped it. And I don't think there's probable cause to stop them. I think the arrest was against the law. It was an illegal arrest, and the rest of it's fruit of the poisonous tree. Be a different story if he'd gone outside and passed the last point of sale. There's no charge for retail fraud here. What you had here is a guy that didn't grab a basket, walking around the store, continuing to shop, needs his hands to shop. So he's carrying the stuff he intends to buy in his jacket.
You can't infer an intent to steal when somebody takes something and puts and conceals them in their pockets or their shirts or their.
Not on these facts, Judge, when he's right by the door, and instead of choosing to go out the door, he chooses to continue to shop.
Okay.
So I don't
Right.
believe that there's a probable cause to, or I actually, it's more technically, it's a move to suppress.
I know. I get it.
Yeah.
I get it. Go ahead. Any response?
Yes, Your Honor, the people to address defense's request, I believe, there's shopping carts for a reason at store. And in this case, that wasn't applied. Additionally, I want to highlight that the defendant not only stuffed these packs of cigarettes inside of his shirt or his jacket, but he went behind the counter. To me, that
I honestly don't need to hear anymore. Defendant went behind the counter. He pulled out cigarettes. There's no evidence whatsoever that would lead anybody under these facts to conclude you can go behind the counter at a store. He takes out the cigarettes. The clerk sees him stuffing them in his jacket. The officer finds them stuffed into his shirt. If that isn't reasonable suspicion to believe that a retail fraud was being committed, you don't have to leave the store. I mean, you mean to tell me that any clerk that's following anybody around, and I'm talking about an investigator, say at Myers or another big store, sees somebody conceal the items inside of their shirt or their pants, has to wait until when they went behind or when they passed the points of purchase? That is not the law. There was nothing wrong about this. It's clearly that infers an intent to commit a retail fraud, and the officer had the right under those circumstances to pat him down. He found him, he arrested him when he believed it to be the fentanyl. So I'm going to bind the defendant over for further proceedings to the circuit court. Is this the only thing he's in custody on, your client, or does he have other holds?
No, that's my understanding. It's just the charge.
So October 21 will be the AOI date. Of course, he has a thick packet here too. He must have quite a criminal history, huh? Wow. Yeah, I can't lower this bond. Bond's continued. AOI date will be October 21. October 21. Okay.
Thank you.
Thank you very much. Can we get that other gentleman out and do that waiver?
See on the 21st.
David on the QCD.
No, I didn't time for our bunch of stuff. But we'll be back at courtesy of asking for a register of action. Thank you. And then that,
Register of actions?
yeah, the circuit court requires that we submit a register of actions with our billing when we're completed. So we have.
Yeah. Yeah, we're gonna have the file taken down. You can go right down there and they'll be glad to make you a copy. Heather, make sure he gets a copy of the ROA, please, okay?
Yes, Judge.
Thank you. No, let's just copy it and give it.
Mr. Nelson is here on the 21st as well. So if I have his arraignment downtown, it's usually like 8 in the morning. I'll come right here. But I'll come as fast as I can.
You can Zoom.
Well, he is his preliminary. Oh, you are correct, Your Honor. I'll just.
You can Zoom unless you have another exam here that day.
No,
Yeah.
Thank you,
Okay,
Your Honor.
no problem. Good to have it.
Thank you for the spirited argument.
Thank you. All right, people against Mario DeQuan Brown, file number 25F726394. Gentlemen,
Good morning, Your Honor. Mohammed on behalf of the people.
counsel?
Good morning, I'm Police Court Douglas Mosky 40906 on behalf of my client, Mr. Mario Brown. Be able to put the full name with Mario Brown.
All right, so this is going to be a waiver, is that correct?
That's correct, Your Honor. I did have an opportunity to discuss this case with Mr. Brown. And after a consultation, he had decided that he just wanted to waive his right to a preliminary examination. He understands there's a problem with cause hearing, where it must be shown that a crime committed probable cause of this to charge him with that crime, knowing that on his waiver, over certain court proceedings.
You understand everything your lawyer just said?
Yes.
Did you sign, read, and understand this document entitled bind over transfer after preliminary examination? You understand you have the right to a preliminary examination on the charge contained in the complaint and warrants, which includes an OWI 3, another was super drunk, another OWI 3rd without super drunk, and then you have a habitual 4th offense notice. Do you understand that? If you waive your right to an exam, you're waiving the requirement that they show that the crime was committed as to each count, and that you were the one who probably committed the crime, and you'll automatically be bound over for further proceedings to the circuit court. Do you understand that? Knowing all that, you wish to waive your right to an exam. Anybody force you to do that?
No.
I'll accept the waiver. October 21, Mr. Mohammed, I know it doesn't matter in this case, but if you could continue to write on these, as I've asked you, no objection to bond waiver or bond continuation, if that's the case. If you do object, you can make a note and I'll call you in, okay? Thank you very much. Bonds continued October 21. Sir, you'll be in the Wayne County Circuit Court for arraignment. I'm sure they're going to do it by Zoom, but that's up to them. Anything else, Mr. Bonds?
Nothing further for the defense, Your Honor.
Have a good day. Anything else, Mr. Mohammed?
No, thank you.
Good luck, sir. Thank you. Do I have any more with you, Mr. Mohammed?
No, I believe we're done.
We're done? Wow. It must be the efficiency of the prosecutor. Huh?
No, we're efficient judge.
See you. Have a,
Thanks.
what's that?
You're very impressed with it.
Have a good day.
You're the fourth judge have been in front of today.
Oh, really?
Yeah, so.
Where you been today?
Circuit court.
Okay.
We have one motion hearing, one sentence, I forgot what the other thing. Oh, no, I then had a Zoom hearing for 36 district on another sentencing on a event case.
Okay.
So, but I like your style.
Well, good to have you here. Take care. Thank you. People against, where's Mr. Shemke? People against Andrew Steven Siak. 25T7174451. Counsel?
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
Sir, your name?
Andrew Steven Siak.
Okay, Lieutenant, your name?
Lieutenant Andrew Green with the Trent Police Department.
All right. You have. I don't believe Judge Hessen signed the complaint. She did a signing on record. It looks like she was preparing to sign the complaint. She did sign the warrant. So Heather, you need to put this file aside and speak to her when she returns, okay? Make sure you tell her what I said. She's looking for a file. All right, so sir, you have a charge of assault with intent to do great bodily harm less than murder, assault or assault and battery, domestic violence second, and knowingly assaulting a pregnant individual second offense notice, which is a 1 year. So, but on the 10 years, so
I just be quiet.
why are you talking? I was talking to you, wasn't I?
Oh, yes, I'm sorry, Dita. I don't even know a pregnant individual. I just don't know where this is coming from. Like, I do not even
Hang
know.
on, slow down, slow down.
Oh, sorry. All right, yes.
Slow down. Okay, that's a second offense notice. My mistake. You got GVH, assault or assault and batteries, domestic second, because they think you had a previous conviction in 17. But the only one you're entitled to an exam on is the 10 year. You have the right to remain silent. You do not have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by an attorney at all subsequent court proceedings. Also, if you ever choose to submit the questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand all of that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. That will be October 28th at 8:45. Preliminary exam will be November the 4th at 10:30 in the morning. Do you understand that?
Yes, Your Honor.
All right. So we're going to talk about bond and we'll go from there. What would you like to say, Mr. Stemke?
Your Honor, my client's not on probation or parole. He does not reside with the individual who is alleged to be the complaining witness. He resides with his parents in Grosse Ile. He has one child, a 19-year-old daughter, and he does part-time work as an electrician. Judge, this might be a refiled case. He has no issue having no contact with the complaining witness. and obviously no contact with the address. I'd be respectfully requesting leniency when determining appropriate bond, potentially consideration for a personal bond. Thank you, Judge.
Say that again. It's a refiled case.
When I read through the police report, it indicated it was there was a police report in there for June of 2025, and I discussed it with my client, and he'd indicated he already gone to court on this matter. I wasn't able to get any additional information, but that's what we thought potentially it was a refiled matter.
I think that's true. At least, can you pull him up? See if those same charges are there.
Wait. I gotta grab my paper.
Yeah, in July, I was dismissed from
Not
judge.
talking, sir.
Yep.
Okay, keep going. Heather, can you hear me? Lieutenant, can you tell me something? What's it 39144 39114 Fort Street?
Those are apartments. A small
Yeah, which-
complex over there. Trenton Village is right by the train tracks. You're heading north on 4th Street, just over the tracks to your right.
And you live on Meridian, correct, sir?
Yes, Your Honor.
Can you tell me any more about what happened here, Lieutenant?
On this one, Your Honor, they go there on a weekly basis for these two. I'm not talking to you. Sorry, I'm talking to myself.
Mr. Siak, why are you interrupting him?
I'm sorry, I was just talking to myself. Bad habit. It wasn't
Talking to
intent, like,
yourself?
intentional interrupt. I'm sorry. Yes, yeah.
Go
Your
ahead.
Honor, the officers go there on a weekly basis. This was one of the more violent offenses that they've gone on. It's kind of it's a constant situation between these two. It's not a healthy relationship. It's quite toxic. I know you're asking about bond. If you're asking for me, I would at least have cash bond with the GPS tether because he's there more than he's in Roseville.
You're not here on this, are you?
I'm sorry.
I was talking to somebody else in the courtroom.
Yeah, on the report, they indicated there at another one. This case number is 7351. They had a 5190 and a 6113, which probably be roughly a month, 2 months prior to this one that they were over for.
10,000, 10%. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with Shelley Zajic or prosecution witnesses except through your lawyer. You're not to enter 3911 Fort Street, apartment 221 in Trenton. You must obtain a GPS tether. You're not to be released from the Wayne County Jail until you're fitted with a GPS tether, and you're not to be within 2 miles of her residence or her place of employment or her. Do you understand that?
Yes, Your Honor.
You cannot leave the state, can't violate a law. You must appear in court as directed. We will see you October 28th. He'll let you start making calls. And you need to come up with $1,000, and it'll take them a couple days, hopefully sooner rather than later, that they'll fit that on you, the GPS tether. So I wish you well. Good luck. Thank you.
All right, thanks, Your Honor.
Thanks a lot, Lieutenant.
Court calls the cases of the people versus Stephen Grisbeck.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Grisbeck.
Kyle Riddle filling in for Attorney of Record Sam Bernstein on behalf of Mr. Grisbeck in the case ending in 1127 with Mr. Grisbeck's permission. Is that correct?
And your name?
Mr. Stephen Grisbeck.
I kind of know that we've seen each other over. All right. What are we doing?
Your Honor, we have entered a waiver on all of these matters, and I'll let Mr. Upperwater put the offer on the record.
This record, attuned to that waiver, people will agree, on the case 25 F1 1127. Sorry, the case for the other FTD charge. He can leave in circuit courts to a reduced charge. Well, pretest is 200 to 1,000. There's no offer currently with regard to the other case, possession of methamphetamine. However, if he chooses to apply for drug treatment report, the people would not oppose his application and would agree to reduce that matter to use if he was to successfully complete that. If he chooses not to apply for drug treatment report, then that case can be further negotiated in circuit court. People may consider a deferred prosecution in that matter pursuant to Mr. Grisbeck completing residential treatment. It is my understanding that he will be going to Sacred Heart in the next few decades. So that's our primary hope, that he do get into treatment and get into the recovery program.
And that is our understanding of the offer, Your Honor.
All right. So he's waiving, however.
Correct.
Grisbeck, is that correct? You're waiving preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on all of this.
Yes, Your Honor.
All right. For the record, people also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court in the 3 cases on all 4 counts.
Acknowledge receipt of information, Your Honor. Waive formal reading, stand mute at this time.
Defendant, every waive formal reading, and you go ahead.
As well, Judge. In matter 1127, waive formal reading, stand mute.
Defendant, every waive formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in these matters will be set for
October 28th at 1:30.
October 28, 2025, 1:30 before Judge Cook.
If you're in recovery,
Bond will continue. He hasn't been, I know I signed orders of release, but they haven't gotten you to treatment yet.
I'm supposed to be leaving tomorrow.
Tomorrow?
Yep.
Mr. Grisbeck, good luck to you.
Thank you, Your Honor.
Thank you, Judge.
Remember, sign information.
We'll get him to you in just a second. October 28.
Oh, nice.
Oh. Court does call the case of the people of the state of Michigan versus Jeremiah Sawyer.
I'll check lost.
Further Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Sawyer, who is approaching the podium. Excited today.
My understanding, please, well, yeah, that the defendant will be pleading no contest to an added count to malicious destruction of building, less than 200. The 93-day offense upon a successful plea to that added count 3. Count 1 and 2 would be. Is there an amended complaint?
Judge, we did hear. All right.
Yeah.
Sorry, Judge.
He did, we're planning to file an complaint that this case going to preliminary examination. That being adding count 2 malicious destruction of building. We recently, students, just adding count 2 malicious destruction to building. For between $1,000 and $20,000. And we would actually have gone on the preliminary examination, dismissed count 1 outright.
Okay, well, then we'll have to start this way. Mr. Feaster, you acknowledge receipt of the new information.
Yes, Your Honor.
All right. You waive its reading.
I do, Judge. I'm sorry.
And how does your client plead?
He stands mute on the arraignment, Your Honor.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to count 2. All right, and now there's a plea agreement in which the defendant would be pleading no contest to an added count 3 of malicious destruction of a building. A 93-day offense. Upon his successful plea, counts 1 and 2 would be dismissed.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the self you got?
Yes.
State your name.
Jeremiah Sawyer.
All right. Mr. Sawyer, it is this court's understanding that you're going to be pleading no contest to the charge of malicious destruction of a building under $200. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property, which is damaged. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Let me explain 2 things about it just to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Sir.
Any question regarding any of those rights?
No, sir.
You'll see a copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
All right. Were you on probation or parole at the time of this?
Yes, sir.
All right. Was it probation you were on?
Probation and parole.
Both?
Yes, sir.
Okay. You understand your plea in this case could be considered a violation of your probation and a violation of your parole. You understand that?
Yes, sir.
All right. You understand that if it's considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Say it again.
If it is considered a violation of your probation, the other court that you're on probation to could sentence you to the maximum that's allowable under the other charge or charges that you're on probation for. You understand that?
He's saying that whatever judge has your probation case, they can sentence you if they determine this is a violation. Like we talked about.
Okay. Yeah. Yes, sir.
You understand that?
Yes, sir.
All right. You understand with reference to your parole, if it's considered a violation of your parole, that you could be sent back to prison to do the remainder of your term. You understand that?
Yes. What's the chances of that, though?
I don't know how to answer that. I don't know.
I'm saying like this.
Like we talked about, it's up to your parole agent. And you said you contact with your agent, and they had a plan for you.
Yeah, but is they gonna like from your experience, right? Is this like
he can't give you legal advice?
Huh?
He can't.
You mean my experience on the bench or my experience with parole?
Like from your experience,
which one you trying to
dealing with
bend something on me? I don't. Parole had what?
Your experience from dealing with parolees, right? They be sending them back for stuff like this. This ain't really serious like that, right?
I cannot answer that because I don't know. I don't know what you've been up to. I don't know what you've been doing. I don't know whether they like you.
All right, man. Yeah, we go. Yeah.
Sir, do you understand that?
Yes, sir.
Now, if you want me to, I don't really want to, but if you want me to adjourn it out so you can talk to your parole officer, I'll do that so that you can be absolutely sure what you're doing.
Want to talk to your agent?
I'm gonna go ahead. It's cool.
You're gonna go ahead with it?
I'm just leaving guys' hands. Okay, so.
Sure.
It all is anyway. All right. So you understand that by entry of your plea, that those two things could happen.
Yes, sir.
And understanding that, do you still wish to enter the plea of no contest?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to flee?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Sir.
And of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-15008. Any objection to the court having reviewed that report?
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant to be guilty of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, and you commit misconduct as defined by the Michigan court rules, any sentence evaluation or agreement the court would no longer be bound by, and you could not withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No. It's on the record, Judge.
All right. And have I complied with the court rule? Would it be proper to accept this?
You have, Judge.
Court will accept the defendant's plea of guilty or of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be. Is this the only thing holding him right now?
I mean, he has a parole hold as a result of this, but just this case, Judge.
Don't I got something sooner, don't I? I have an October day.
We'd appreciate it.
Hello? I have an October day.
You have October 22nd.
Thank you. Yeah. Sentencing will be October 22nd, 2025 at noon.
Thanks. Thank you very much, Judge.
You're welcome.
Sir.
Bond will continue. Thank you.
Your Honor, we have executed an advice of rights in a plea form and a sentencing judge waiver.
The plea form indicates that the defendant will be pleading. Hey, you didn't check the box. It's a no contest plea.
It'll be a NOLA plea, yes, Judge. The reason being civil liability.
We're pleading no contest to the charge of aggravated assault. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That is correct, Judge. There is no sentencing agreement in this matter.
They haven't sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Brandon Kelly.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Not this time.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
I have been provided and have reviewed Ann Arbor Police Department report for their case number 25-31672. Any objection to the court having reviewed that report?
No. No from the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, I should say. And you would not be permitted to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No. No, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be November 4th, 2025, 9 a.m. That is before Judge Valvo. Bond will.
If I could be heard on bond, Judge.
Sure.
Your Honor, Mr. Kelly is here on he's a 5,010% bond. He has resolved the felony matter. He has taken responsibility in this matter. His mother has been in court with him every single time, and she's in the front row here. She says that he is welcome to stay with her while he's out for sentencing, and we'd ask the court to grant him a personal recognizance bond, and with any conditions. I think he'd welcome any conditions that would ensure the safety of the public. Up to including potential tether and no going to Target. This is an event that happened. Well, you read the police report. You know what?
Yeah. Well, I'm concerned about why it entirely happened from his perspective. I guess maybe I'll ask it a more direct way. Are there CMH issues?
Yes, Your Honor. He has there are CMH issues. He has an alternative treatment order. He has received his shot. I believe he's just received it not too long ago. Is that correct? Yes. When was the last time you had him? I can't remember. But I don't think he'll be due for another shot before he's sentenced. Is my understanding. Don't quote me, but last time he and I spoke, he had just gotten it, and this matter was set for an exam.
Is this right? Is this his only case?
I don't believe there's anything else holding him, Judge. No.
That's what it looks like.
And
I think it's back up.
right, and the treatment plan is through probate court, I presume.
Yes, I believe so. If I could just have 1 second, Judge, I have my notes.
Well, I guess the other thing I want to know is, was he on the treatment plan prior to this event?
If not prior, Judge, I believe that the two may have coincided.
Well, I get okay. So here's what I'm trying to figure out: if he's on the plan prior to this event, and then after this event, he then gets onto the plan. That's one thing in my mind. If, however, he's on the plan prior to, maybe not cooperative with that, and then this happens, that's a different issue for me.
Your Honor, he reports that he's just been receiving the shot for the last month.
Oh,
it would have been after the plan. This precedes the shot here.
What I will do is, I'm not going to give a PR, but what I would indicate is that I will reduce his bond to a 1,010% bond. I really would prefer that Judge Valvo, since she has it, take a look at it, given her history with the mental health court. Take a look at it. I'll reduce it to the 1,010% bond. Will also indicate prior to his place on the GPS home confinement tether.
Now, I will get that address to the court, Judge.
All right, very good.
Thank you.
Thank you. Let's call the case of the people versus, is it Antoine Pitts?
Council Overwater, Assistant Prosecuting Attorney on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I have the plea agreement and the dice of rights as soon as he signs. It just sound right. And 14. And this is the advice of rights form. You've been over this before. You need to sign it.
Plea form that has been given to the court is that the defendant would be pleading to an added count 3 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is also an agreement that the prosecutor is going to recommend release on a PR, and he signed the sentencing judge waiver. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Your Honor. Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth so help you God.
Yes.
State your name.
Antoine Pitts. All right, sir, it is this court's understanding that you are going to be pleading guilty to a charge of use of a controlled substance. Yeah. Correct? That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that, sir? Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Yes. Still wish to plead guilty? Yes. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No, sir. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? Probation. Okay, were you on probation at the time this happened? Yes. All right. I need you to understand that this could be considered a violation of that probation. Yes. You understand that if it is considered that, that court could sentence you to the maximum allowable under that other charge. You understand that? And understanding that, you still wish to plead guilty to this one? Yes, sir. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes. Of your own free will? Yes. All right. And because you believe that you are guilty? Yes. December 3rd, 2024, at the location of Bryan Circle at or near Thetford. Did you have cocaine in your possession? Yes. Had you used it? Yes. Did you know what you were using was cocaine? Yes. All right. The court has to also advise you, sir, that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that? Yes. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None that I'm aware of.
No, Your Honor.
All right. And sir, and counsel, have I complied with the court?
I'm satisfied, Your Honor.
The court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be November 18, 2025, 10 a.m. before Judge Barr. There is an agreement for the release at this time.
Your Honor, the answer is yes, but I'm going to ask the court to do something which is a little bit abnormal. We're asking that the bond previously set, which had been posted, be reinstated, but we want it effective as of next Monday. The reason for that, he is on probation to Judge Hammoud. We have a hearing in front of Judge Hammoud, and as of right now, he's not going to be released. So we'd like the clock to keep running at least until Monday.
So when's your hearing before Judge Hammoud? On
Monday, 20th.
The 20th?
Yes, Your Honor.
And all right. So what I will do with reference to his bond, at this point, I will continue his bond, but then defendant to be released Well, I don't want it that way. Defendant's previous bond is reinstated. Effective October 20th, 2025. And I'm just going to put in brackets on here that defendant has posted prior bond. That does what you want.
Good. Thank you, Your Honor. That's for me. I'm not here.
Is it you?
Absolutely. Sorry.
Was it?
Yeah, it was.
Hey,
I know, right?
hey.
Send me home.
Get no. No, give your phone to Alan. Thank you, sir. Yes.
Okay.
Yeah, granted in part, denied in part. Just I wrote it,
Yeah, I
so
saw
you
it.
just put it.
Cool. Please.
Court does call the case. People versus Mankisha Malcolm.
On ground, Deputy Public Defender, Prince Grid, and on behalf of, please state your name for them.
Good morning, Your Honor. My name is Markeisha Melcher, and I apologize for being late. I'm sorry. I was at work and rushing this morning, forgot my court date. I didn't look at my little recovery calendar, but I made it.
You know what? I'm gonna like you.
Thank you.
Yeah, no, the only reason is because you confessed to something I didn't know. So, we're gonna get along just fine. All right. Apologies accepted. Man.
Thank
That's
you.
fine.
So,
All right.
today's the date and time set for PE. We have a plea agreement worked out. My client has signed the waiver of examination. We're ready to proceed.
All right. And it's mine anyway. All right. And the plea agreement I have before me indicates that she's going to plead guilty to an added count to a retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes. May I have her sworn?
Right here. Stop for the firm testimony about to give. So we got.
Yes,
State your name.
Markeisha Melcher.
Melcher, it is this court's understanding that you're going to plead guilty to the charge retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Oh, yeah.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, I am.
All right. Were you on probation at the time of this offense?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
March 30th, 2024, at the location of 3300 Carpenter Road, Pittsfield Township, Washtenaw County, state of Michigan. What did you do at the Home Depot that makes you think that you're guilty?
I entered Home Depot with someone and attempted to take something.
What were you trying to take?
Flooring.
Flooring.
Someone flooring.
All right. And so you were trying to walk out of the store without paying for it?
Yes, I accomplished someone. Yes.
Okay. So just so that we're clear, when you went in, this other person that you were with the two of you were really acting in concert to get out of the store without paying for the flooring.
Yes, Your
Was that correct?
Yes, Your Honor.
All right. And the value of the flooring, was that in excess of $200?
I'm
We
not
don't
for sure.
contest.
Well, we'll do it this way. You have subsequent convictions for retail fraud
Yes.
in the 24th District Court in 2017 and in the 34th District Court in 2024. Is that correct?
Yes.
All right. Store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No.
And this property you took was property that was offered for sale by Home Depot?
Yes, Your Honor.
Ma'am, if I accept your plea and you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentence, you understand that you would not be entitled, or the court would not be bound by any sentence evaluation or recommendation in the case.
Yes, Your Honor.
All right. And you also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
The defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me. Bond will continue.
Thank you, Your Honor.
So next time you're going to be on time, right?
Yes.
Okay, me too. All right. Thank you. Ready to bring this guy out.
So then the witness talking to his client. Quick.
He's talking, so he went back to talk to his client. The Warren Greens. What? Yeah, I appreciate it, but what are you going to do?
It may not, it may be counterproductive. It may be counterproductive.
And that would be your MO. So get over here and sit down. Yeah. I have to give you a hard time. That was kind of a Maryland thing. Court does call the case of the people of the state of Michigan versus Max Stewart.
Assistant Public Defender Ben Denworth on behalf of Mr. Max Stewart, who is joining me at the podium now. Sir, would you state your name for the record, please?
Hezekiah Max Stewart.
And Your Honor, I do believe we have a deal for a waiver of exam in this case.
Okay.
In exchange for waiving his exam, the prosecution is offering to let my client plead guilty to counts 2, 3, and 4 at a future date in the circuit court. And at that time, or at the time of sentencing, count 1, the 10-year felony would be dismissed. Is that correct?
That's correct, Judge. It was
Okay.
He pleads to count 2, 3, and 4 in a circuit court.
All right. So, but he's waiving his preliminary examination. Sir, is that correct?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
For the record, people also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, he's just signing the form now.
Right. While he's doing that, you waive formal reading. Your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will be set for October 27, 2025, 1:30 before Judge Hamoud. Bond will continue.
Your Honor.
Thank you. Pardon?
Can I run down to our office and grab a HDMI cord?
Sure. An HDMI cord? Is that what you need?
Yes.
We got.
There's one here, but I don't want to take it.
What are you gonna play something? Video? You can. The cord can be moved, but you can also play it from the podium if you need to.
Okay.
So either way, if you want to go grab one, go ahead. Take a stroll. We'll be here. No, that's okay because I've got a case I can handle and then.
Okay.
All right. Or one that might handle me. I heard that. I said no, they're not. I'm not talking to them. I'm not no. With you two, it could get real bad. It could just get bad. I'm just coasting along during the day. And the things people were saying about you disappeared. No, I was defending you. I was what? Oh, it was horrible. It was horrible. Some of the things they were saying. Wasn't it bad? It was. It really was. Is this like an approach, or we need to sit down and have the conversation?
I'm trying to avoid your chambers. I feel bad making people's time up if it's,
What?
I feel bad making time up if we can. But I'd be happy to oblige for whatever.
She's so demanding. She just has her way. I'll see them in chambers because they're gonna yell at each other. They were both. I'm watching the two of you, and you're over there with each other, animated. And then, can we approach? Let's going back. I'll talk on that when everybody remains seated, and when Warren Green and I don't have one. Never one. I'll deal with that. 50. One not yet, so easy. Court does call the case of the people versus Jeffrey Sander.
Good afternoon, Your Honor. I'm prosecuting attorney.
And Laura Yagi, Assistant Public Defender on behalf of Mr. Sanders.
Laura Worth. And
So, Your Honor,
go ahead.
was that a time set for preliminary examination? Before we even got to that point, there was some conversation I had with defense counsel regarding proceeding with this case, and also information I received that there is a CPS investigation. That investigation is based on the reports that defendant has been living with, or at least at the very least staying with the victim in violation of his PPO as well as violation of his bond conditions. I informed counsel of that. I know we had a chambers conference regarding that matter. It was people's position that we were going to ask for remand to keep him in custody until we could have a bond violation hearing and to adjourn the exam to follow. The victim was not present here this morning, although there was some back and forth about whether or not she was on her way. The victim had expressed great fears about showing up here today and what the defendant would do if he knew that she was going to testify. After our chambers conference, Your Honor, I came out to call the victim. There was some conversation about having the victim appear via Zoom. So Deputy Raymond Hall and I called the victim to have a conversation with her about the possibility of her doing that. During that conversation, towards the end of the conversation, she caught our attention as we were hanging up the phone and said the defendant had been texting her throughout this whole day, essentially, throughout this whole procedure, and that she wanted someone to go look for him because he had texted her that he was going to run. I then left the conference room right away. I informed Public Defender Yandi about what we had learned and I was looking for the defendant. My understanding at that point from Ms. Yagi was that the defendant was going to go use the restroom. I came out in the hallway. That is what he claimed he was doing. I had Deputy Raymond Hall follow him based on what we had just learned. Next thing I know, I was back in the courtroom. I heard police stop. And when I went out in the hallway, the defendant was no longer there. And it was my understanding that he had taken off.
In my understanding with reports from security that he took off and would be the southern emergency entrance out of this building headed in a southerly direction. Ms. Yagi, anything?
Your Honor, I don't think there is anything I need to add at this point?
Based upon that, and this date and time set for preliminary examination, I'm going to issue a bench warrant for the defendant failure to appear. There will be no bond. That warrant will issue immediately. I have also marked the file that this matter, initially anyway, it might ultimately be set before Judge Washington, but should be set before me when we get him, and we will.
Thank you.
All right. Thank you. Okay, because of an emergency, I had to cancel my civil docket.
Oh.
And let me just double check. And so I handled the criminal docket that I just finished up. All right.
Yes. She was.
Thanks. Appreciate. All right. So the cases from today, they're here on a civil matter
They went to the 28th
at 9.
at 9 a.m. Yeah.
Okay. So we had to move those 2 weeks out. Sorry, folks.
You all there? Man.
You've been here all day with me? How'd I do?
You did a great job.
Well, thank you. All right. You take care. We'll see you in a couple weeks.
Okay.
Yes, ma'am.
Ma'am, if you see the clerk's office, they can give you a notice to take with you.
Okay. Go for it.
I think he should be in custody.
No, I'm wonderful. Yes.
A bit problem, Your Honor. So I don't know.
Pardon?
Or one of I'm sorry, on Mr. Sanders, they found him. They have him.
They have him?
They have him. Excellent police work. I don't know if the court
Best in the state.
do anything today.
Oh, yes. If you guys have time, let's bring him to me.
You're on the mail. I'll go and pick him up right now. He's just around the corner.
Fantastic. I'll be here with bells on. All right. Court is standing brief recess. I need that file back.
I will pull you in.
Well,
What team usually court can kind of watch it on say eventually or not like it.
you may be seated. Court does call case of the People versus Jeffrey Sanders.
Good afternoon, Your Honor. Ray Piano, Assistant Prosecuting Attorney on behalf.
And Laura Yagi, Assistant Public Defender, waiting on behalf of Mr. Sanders, who is to my right.
Jeffrey Sanders. All right.
Your Honor, before we start, I also just received a text message sent from the victim to the officer in charge, Deputy Hall. It's a screenshot at this stage. Of course, we need to get more information. It's a screenshot from someone named Jeffrey saying, you okay? If you want me in jail, just say so. She said, I don't want you to. That was read by him at 11:42 a.m. Then he says 9 out of 10 times I am. Then he says he back. Then he says, can you talk? Then he says, I'm going to run. This seems to coincide with what the victim was telling us towards the end of our conversation.
All right. So I don't know where you want to start.
I frankly, I don't either. I think what I would request today is that this be set, reset for exam and set for bond violation hearing, because at this point today, I don't feel prepared to go forward on the bond violation aspect. To be candid with the court, I just need more time to talk to Mr. Sanders about these allegations that I just learned about a few hours ago, and I need to go through them in more depth and more detail with Mr. Sanders.
Okay, but as just so that we're clear, as we were going through the conversation this morning regarding certain reports and certain other things and certain allegations by the alleged victim in this case, in a lot of ways is referencing his status right now. Aren't those irrelevant to the court? I mean, because, well, I won't say absolutely irrelevant, but for the purposes of today, certainly they're no longer relevant. I mean, even if, which was the court's attempt to try to determine as to whether or not he might pose some threat to the victim in this case, I don't even know that I need to go through that part of the analysis because clearly he's demonstrated that he's a flight risk. And so he's not going anywhere today. I mean, I hope he enjoyed his little last half hour of freedom. And so, I mean, there's that issue. And also, we were getting indications, and they will get them, that he was texting the victim and he's got a no contact. I mean, I'll set it for a hearing, but I don't know.
I think one of my questions, well, the first question would be obviously, is there a bond violation? The next question is what is the appropriate sentence for that bond violation? One of the things that I do think is especially relevant is I do think it would be relevant for the court's consideration in terms of a sentence for a bond violation, the context of the conversations. And I don't have that at this time. And I think it would be important for me to be able to prepare and for the court to have, because, I mean, I don't want to necessarily go further today, but I think it does make a difference if there is contact with someone, versus if someone is calling, texting, and saying, will you respond? And then there's a response. I just think it matters in terms of sentence, even if it doesn't matter in terms of whether or not there's a violation, because one of the things that the state's witness said this morning was that she had been reaching out and asking for a response.
Your Honor, first of all, I'm sorry, may I?
Yes.
First of all, I don't appreciate that my conversation that I had with a victim in this case was overheard, listened to, whatever it may be. The part that's now being put on the record is also a great deal about why that victim did not show up today. And as we witnessed, quite frankly, she probably had good reason not to show today, because I don't know what defendant would have done. And I had to call this victim. I had to have deputies go out and have our victim advocate contact her and essentially tell her, take your kids and run, get out of the house, because that's very likely where he was going after finding out that she was going to appear on Zoom. I mean, she was willing to appear on Zoom and testify today, despite all her hesitations. And he decides to run, and he's messaging. I cannot imagine a context where that is okay or acceptable or excusable in any way. We are here for a court hearing, and he is messaging her as we're talking to her. So I want to be very clear. I don't think it's appropriate to further put any statements the victim made on the record in front of this defendant, because quite frankly, we're just increasing her risk here. This is high lethality, 100%. And we are not going to contribute to making the risk for her even greater than it is by talking about statements she made in confidence speaking to you. We're just not going to do that. So I would ask Ms. Yagi to stop right there if she's going to get into further anything that's to do with what the statements the victim made.
I understand. I will request that it be set for bond violation hearing. I don't feel prepared today to address it. I think there are statements that are discoverable, and so I'll follow up with the prosecutor about that.
An effort to be made to have the victim available next week.
We'll do our best, Your Honor.
All right. So what I'm going to do is I'm going to, first of all, adjourn the preliminary examination. I'm going to keep the case. It would go back to Judge Washington on the 28th, but we'll get it heard sooner if I keep it. So I'll set the preliminary examination for October 21st, 2025, 9 a.m. That will be before me. I'll also set a bond hearing. We'll hear it sometime that day. Bond violation hearing. Anything you want to say before I do what I'm going to do regarding bond?
Not from me, Your Honor.
Mr. Sanders, I'm just going to say this before I do it because I think it's important. Your attorney was back there, her and the prosecutor, going back and forth, and I'm sitting there listening. And I tried my best to make sure that every opportunity was at least afforded before any presumption was made regarding any contact, regarding any of that, by having the victim appear via Zoom. And you decided that you were just going to not pay attention to any of these proceedings, do everything your own way. My understanding is you told an officer in the hallway that you weren't going to go anywhere, that you were going to the restroom, knowing darn well that you were just at some point trying to find your way out of this building. I was also informed that at some point, which may lead to additional charges, when they're telling you to stop, you just kept going. And maybe you need to also understand this, that you set off in this building by going out an emergency exit, an incredible amount of protocols in this building to keep everybody here safe when you went out for your little half an hour jaunt where the heck you thought you were going, with the thought that you weren't going to get caught. If the court had made up its mind that I wasn't going to incarcerate you, you changed that. This is all you. Because as I vindicated, I have to be concerned about two things. One, at least before now, I wasn't concerned about you being a risk of flight, but I have to be concerned about that. And I have to be concerned also about the protection of the public, but particularly the victim in this case. My heart of hearts tells me that at some point, that's where you were headed. To terrorize her more because you were gone. And because you left, had all kinds of court security down this way trying to figure out what was going on. All kinds of debt. You threw law enforcement into this whole world of trying to find you. At the same time, trying to protect her and those 4 children. Because there was no telling what she would do. So you might as well get used to one thing. You've shown me what you are at this point. I don't have to try to hear a whole lot from people about what you are. Because I think you were going after her. And I'm going to tell you, on my watch, that's not going to happen. Defendant's previous bond is canceled. Defendant's bond is hereby ordered revoked. Defendant is remanded.
Yeah.
Is that it? 14A stands adjourned. I'm good. So who got him? Was it Pittsfield?